Jacinda Ardern.
Thank you, Mr Speaker. It's my pleasure to speak on the second reading of the Legal Services Bill, and I just want to begin by agreeing with the comments made by my colleague Paul Quinn over the way that the Select Committee really worked together on this bill and most bills that come before us, but also to express my sadness that I'm no longer a member of that committee, and I really have enjoyed the opportunity to be on a committee chaired by Chester Borrows. He has always conducted himself with integrity on that committee, and I will miss his good grace. But in the meantime, I of course was still a member of the Committee for the Legal Services Bill, and as has been pointed out, of course this bill probably wouldn't exist in this form had Dame Margaret Baisley not completed the really scathing report that she did on the way legal services were provided in New Zealand. And I do think it's important that as a Parliament we responded with speed to that report, because of course one of the important pillars of our justice system is that people continue to have confidence in it. And it was important in particular that when it comes to people accessing the justice system, which so often is eased by the availability of legal aid, it's important that people have confidence that they are getting a high quality service, and at the same time we're getting value for money through for the taxpayer dollars, the taxpayer dollar as well. I want to touch on though one particular point first off. We heard very early on as a committee from the Legal Services Agency Board that of course there were concerns amongst the legal fraternity, particularly in Manukau, that the report really had cast a dark shadow across all of the legal profession in that area. When we do need to keep in perspective that of course not every lawyer working in that area was one of the ones who were rorting the system, although Dame Margaret Baisley made the statement, and I'm not sure that this was necessarily backed up by evidence, that 80% of lawyers working in legal aid were gaming the system, and that another 200, she believed approximately, were rorting it, gaming being using procedural points within the court system to allow themselves to delay proceedings and draw down further legal aid. Now, whether or not that was the case, from our Labour's perspective in particular, we called on the Minister of Justice to meet with the bar in South Auckland in order to really smooth the way going forward, and in particular to enable us to ensure that when we do come to implement these changes, that it's done so smoothly, and that we don't allow a perception that all lawyers working in the system are rorting it, because that certainly wouldn't be the case. A couple of things I want to touch on, though, that my colleague David Parker has already talked about. We are pleased to see the extension of the Public Defence Service. That was something that Labour raised in 1999, and via a pilot scheme found that we could save up to $1 million by having salaried lawyers available, public defenders, and also a standardisation of high-quality defence. And pleased to see that that's going to be rolled out in further centres. I wouldn't mind, though, if the government could explain. Dame Margaret Baisley had suggestions for where it should be rolled out. The government's responded with only rolling it out in Hamilton, Wellington and Christchurch. I believe Palmerston North has been left off the list, and I'd be interested to know why that is the case. Also pleased that the government and at the Select Committee we were able to work through some of the issues, the very important issues raised by community law centres. I want to come back to that. But also just to very quickly make the point that it was raised with us quite frequently, the idea of making sure that when we're bringing in an agency which has previously sat independently of the Ministry of Justice, that we were ensuring that the lines of reporting were transparent and had enough separation from the Secretary of Justice and the government to allow the public to have confidence that there was a good separation of powers. And I think that we managed to ensure that in the end. One area, though, where I continue to have a couple of concerns, the Legal Aid Review Panel was disbanded under this bill, and the legal aid review function will be carried out by the Legal Aid Tribunal. But also the board, which existed specifically for community law centres to have access to the Minister of Justice, has also been disbanded. And there was concern amongst the community law centres around their lines of communication with the Minister of Justice. Now, we reached a middle ground, I guess. We assumed, of course, that via the requirements in this bill for the Minister of Justice essentially do capture a requirement to continue to liaise and communicate frequently with community law centres. But those weren't explicit. That wasn't explicit in the legislation. Now, whilst we might be confident that the Minister, the current Minister, Simon Powell, would conduct himself in that way because he has continually expressed his support and demonstrated it in times of funding shortages, that cannot always, of course, be guaranteed when we move through Ministers of Justice. So I'm still of two minds as to whether or not we've written in enough protections there for the community law centres. But that's something that I'm willing at this stage, to proceed. There are protections in this bill. Whether they're far enough, I think, will be tested. And that's something that I would encourage community law centres to continue to monitor and come back to this Parliament if they find that that relationship is inadequate. We've already had David Parker talk about the Select Committee's discussion over the preferred lawyer, and I want to put this on record again because on the face of it, removing the ability for a defendant to choose who should represent them in low-level criminal cases, and I do want to make that distinction because it is only in low-level criminal cases, may seem like it's somehow a backward step, but it was very interesting on the Select Committee to hear evidence which demonstrated to us that actually preferred lawyer doesn't mean necessarily that the person is being referred to the best lawyers available. In fact, Dame Margaret Basie's report demonstrated there were backhanded payments going out for referrals to particular legal aid lawyers, and often those who were most frequently used then became, by default, there became a cycle of them becoming the preferred lawyer, when in fact they may not have been any more competent than another lawyer who was used far less often. Also, we were satisfied that there were enough there was discretion built into the legislation to allow, as David Parker said, for cases that involve domestic violence or children where continuity of lawyer is important, but also cases where it may be important to make sure that a defendant who may have a language barrier, for instance, is appropriately paired with a lawyer who can communicate with them. We felt there was enough discretion in the bill to make sure that that could still occur, and we were satisfied by that. That, coupled with the fact that there was a threshold, which meant that we weren't talking about serious criminal cases, but lower level, meant that we were satisfied that removing the preferred lawyer at that level was an appropriate measure. I just want to spend my final few moments reflecting on one of the concerns brought before us by the community law centres around legal education, because it did strike me by the end of our hearings that there was perhaps a misconception over the level of change from the old Legal Services Bill and this one. The old Legal Services Bill held a definition which included legal education as a legal service. This bill still does as well, but it's slightly separated out. So I just want to point out for the record that under community legal services in Part 1, Clause 4, it states that community legal services mean any one or more of the following services that a community law centre provides. A, legal services. B, law reform and advocacy work. The bill then goes on further on in the bill to define what legal services can include. And that under legal services over the page it states, in relation to legal aid means legal advice, representation, etc. And then it states in B, legal advice and the provision of legal information and law-related education. So as though it's not perhaps as succinct as the previous bill, there is still a connection there in the definitions. To make it even clearer as a Select Committee, because we did hear the concerns of the community law centres, have added under the functions of the Secretary for Justice a specific clause, FA, that one of their functions is to undertake or fund law-related research and education as well. So not only does it sit under the definition of services provided by the community law centres, we've made it a specific task as well, an ability of the Secretary for Justice to ensure that they are
Sorry to
also
interrupt the
able
member.
to
Her time has
undertake
expired.
education.
Dr.